Blow dry, no laundry. When I heard her decided they were charged by the that's definitely more sensitive to because I don't have like you know how I always love to get my hair straight and cut and she's like, you know, she's talking about
Alright, good morning, Go ahead and get started here. Pass out the utility sheet. Everyone okay? Do we like Schaefer or do we not like Schaefer? I'm okay with that. I'm trying to figure out today's 15 minutes. Blue Schaefer's alright. At least Schaefer's like a not so old, 1977, I believe. That's better than at least the language. Let's give it that. At least the language is like normal language, right? Yeah. Okay, can I get one positive here? So we go ahead.
Hanson wasn't also third Marshall opinion? No wait, I'm sorry, next case.
Okay, guys, here we are. We left off discussing Hanson. Oh my God. That was a student note that we left off discussing the Hanson case, so we will pick up there. I'm so bored. I'm like a big college football fan and no college football on. I'm just like bored. Bored. I already watched Bird Box. Everyone watched Bird Box. 50%. Was it all the hype you thought it was?
The meme social media made it better.
Okay, I was like, don't give away the plot. Bird Box is a movie on Netflix that's, I think Sandra Bullock, starring Sandra Bullock. And I kept seeing all the social media hype, so I'm like, you know, you never want to feel like you're missing out. So
that's the only reason I watched it.
I watched it. I thought it was interesting. The ending wasn't like as impressive as I thought it could be. But
It's a hit or miss for most people.
yeah, so
I still thought that was something when I realized it was over now.
yeah, that's impressive. So if you hear any good Netflix movies, let me know.
Fresh, have you seen Fresh?
Okay, Fresh is one. Just let me know. How many people do Hulu in here? So, excuse me. I'm sorry, I'm like really frugal, so I have like, I keep creating new email addresses just to do the Hulu trial.
They call us.
Yeah. No, they go back and forth though. They take it off. I think it's
So how does that be getting left and then if you got to
Alright, so
go?
I'm gonna do all back in. So we will start with that Hanson case. I don't know what's going on with these notes. And go from there. Where's my Schaefer? Schaefer. So, I'll do it short right now. So for our attorneys today, let's have attorney Jamie Scowcroft. I like that last name. Yeah, it's different. And since Schaefer is such a graphic case, someone want to volunteer and everybody love you? Oh, okay. Just checking. Jamie, we need to find your counterpart. Let's do Nathan Bearden. Where are you? Oh, are you volunteering? Oh, everybody who loves her. Schaefer, so many crappy case. What's your last name? Richter, you were a rock star. Thank you for doing that. All right, so I've got Richter. Okay, so do you mind giving me the facts, attorney Scott? Did I say your name correctly? Sco, right? Okay, good. Yes, Nancy. Thank you.
So, Ms. Bonner created a trust as you live in Pennsylvania, but the trust is created in Delaware. And after created the trust, she moved to Florida, which very much agrees with if Florida could acquire jurisdiction over the Delaware trustee.
Okay, so unfortunately I'm like struggling to hear you, so can you try just the facts a little bit louder? You don't have to yell, but
Yeah.
okay.
So I'll just start over. So, Ms. Donner created the trust when she lived in Pennsylvania, but the trust was created in Delaware, for the Delaware business, and then she moved to Florida.
Perfect. Keep going. You're right.
And then from there, it pretty much tied into like whether Florida could acquire jurisdiction over the Delaware trustee.
Okay, perfect. All right, so she did a great job on the facts. So, I think a pretty straightforward case here. What's going on? We know that Mrs. Donner established a trust in Delaware, as Ms. Scowcroft said. Did I say your name correctly? And that Delaware Bank was named the trustee. So we all know that banks sometimes might be trustees over beneficiaries' policy. So at this time, what's important that we care about in terms of citizenship purposes is that Mrs. Donner is a citizen of Pennsylvania. Okay. So again, the trust established in Delaware. Mrs. Donner is a citizen of Pennsylvania. The trust allowed her to make an inter post and testimony appointments, meaning she could transfer who's a beneficiary of the trust. She later moved to Florida. Okay, and while in Florida, she executed her will, and the will was probated in Florida as well. So you can already see when we start mixing up states like this that it's going to create some jurisdictional questions, which is what the court addresses in this case. And so the issue in this case, as your colleague just stated, concerns whether the Florida court could obtain jurisdiction over the trust based on the law of trust in the states, and whether Florida had jurisdiction over the trust, depending on whether Florida could acquire jurisdiction over the Delaware trustee. So again, trying to figure out if Florida has personal jurisdiction over this trust, and if they can assert personal jurisdiction over this Delaware trustee. They can make this Delaware trustee essentially be bound to whatever judgment they find. So why does it even matter if Florida had jurisdiction? Why does she care? Like, why do we even care, Attorney Richter?
I'm not super clear about the law around it, but I was getting the impression that there were 3 daughters, and if they were able to, if Florida was able to get jurisdiction over the trustee in Delaware, 2 of the daughters would receive everything and the third got nothing, and if they didn't have jurisdiction, then all 3 daughters would share equally.
Absolutely perfect. You're not sure, but you hit it right on the nail. So yeah, it does matter whether or not Florida has jurisdiction to these daughters, because it's going to determine how much money they get. So I care. If I'm going to get half or possibly none, I care whether or not Florida has jurisdiction. So again, if Florida had jurisdiction, the 2 daughters would receive everything, and the third daughter would receive nothing. If Florida doesn't have jurisdiction, then those 3 daughters would split the trust amount equally. So yeah, that's why it's a big deal here. So what were the trustees' contacts in the state of Florida? Attorney, the lawyer name, Scowcroft.
So first of all, they failed to find any contracts, like in circumstances like from like the bank in Florida, like Florida didn't have any contracts.
Okay, I think you said the court found that the bank didn't have any contacts with Florida. Is that what you said?
Yeah, we failed to find such contracts in the circumstances of this case. The defendant trust company has no office in Florida and transacts no business.
Say it confidently.
So like, there's no, like the trust company has no offices in Florida.
Okay, so that's you know, what we're learning from these cases is how do you determine if someone has minimum contacts, if they're continuous and systematic, what do these contacts look like? So in this case, the court's saying that, you know, which is a good point, the company doesn't even have an office in Florida, they don't transact any business there, none of their assets have ever been held or administered in the state of Florida, so they're not seeing any meaningful connection or contacts with the state of Florida. And more important, there's no solicitation of business to the state, right? By person or by mail, like we saw in the previous case with International Life. Remember, that all happened via mail. So the only relationship then that the trustee has in this case with the state of Florida was that she sent the trust proceeds to Mrs. Donner while she lived in Florida, but the court says that the record discloses no instance in which the trustee performed any actual acts in Florida. And I think that's on the second to last paragraph on page 90. So based on those lack of contacts, what does the court hold in this case, Attorney Richter, and what's the court's rationale? Please.
That the Florida courts could not acquire jurisdiction over the trustee of Delaware. It failed the minimal contacts test, and I think a lot of it had to do with the fact that the woman who bought the trust originally took it with her down there, so it's different than the last case where they actually did into the state before the business wasn't unilateral. They said that it failed the
What is a unilateral act? Is everybody familiar with that term? Okay, some did this, some did this. So unilateral act is me, like say I'm in a contractual relationship with someone, and I decide to move. The contract says we're just supposed to be doing business with local Kentucky people, and I go ahead and enter a contract with someone in Indiana without my co-partner or co-business owner's knowledge or approval. Well, that was a unilateral act that I made. It means I made it on my own, and therefore I can't hold my co-owner responsible for an act that I did on my own, even though we're the same. It's a unilateral act, meaning you can't basically go, what do you call it, rogue. So that's essentially what they're saying. So you don't want to hold a company like this trust company liable just because she chose to move to Florida. They don't want to do business in Florida. They have not solicited any business in Florida. They've done no transactions. Like, so then you expect them to come to Florida and defend themselves, with Florida law to be governing? Like, that's not fair to that particular trust company. So that's essentially a very simplistic way of saying what the court is saying here. So we know that, as Attorney Richter said, the Supreme Court found that the Florida court did indeed lack personal jurisdiction over the trustees. Again, as she stated, they found when they looked at the contacts, they were not systematic and continuous, so not minimum contacts. Again, they had no offices in Florida, didn't transact any business in Florida. The controversy centered on the validity of the trust, and the trust was created in Delaware. That was another thing that they listened to. So, and the trustees again did not direct any activities specifically trying to do business in the state of Florida. I believe at the bottom of page 90, sometimes my page is a little off. Yes, so on page 90, the court goes on to say, and I'm just going to read a direct quote from the case, the unilateral activity of those who claim some relationship with a non-resident defendant cannot satisfy the requirement of contact with the foreign state. And again, the unilateral act the court is referencing is the fact that Mrs. Donner moved to Florida. It's a unilateral action, and that alone is not enough to show minimum contact. So someone else can't create minimum contact for a company simply because they change residence. So what does the court require on the part then of a non-resident defendant in order to justify a state's exercise of personal jurisdiction? On that same page, the court says, and this is a direct quote, it is essential in each case that there be some act by which the defendant, and this is very important, purposely avails itself of the privilege of conducting activities within a foreign state, thus invoking the benefits and protections of its laws. I'm going to say that again. I hope that you'll underline it in your book. It's important because now what we've done is we've added another part to our international shoe two-part test. Okay, another requirement. So we're expanding our framework that we're going to use for exam purposes and practice. So again, on page 90, the court says it is essential in each case that there be some act by which the defendant purposely avails itself of the privilege of conducting activities within the foreign state, thus invoking the benefits and protections of its laws. So the big takeaway from this particular Hansen case is, the majority of this case basically left no doubt that the significance of contacts between the forum state and the defendant was very central to determining whether or not there were minimum contacts, right? The language to remember is the concept of purposeful availment. Okay, that's what's super important. The defendant must purposely avail itself to the benefits of the state. Okay? In other words, from the Hansen case, we learned that in order for there to be minimum contacts, the defendant must purposely avail themselves to the benefits of the state. So if we think back to the previous case we discussed about the life, I think it's International Life Insurance Company. If you purposely avail yourself. So if I'm Amazon and I am trying to solicit business in Kentucky, there are commercials coming on showing Amazon when I'm watching television. I'm seeing ads posted. They have salespeople here, in the malls handing out leaflets. Check out Amazon.com. You can shop online, free shipping. Well, they have purposely then availed themselves to jurisdiction in Kentucky, right? If all these other things are present as well, we're going to learn them. Now, what you know as a future attorney is that in order for a state to assert personal jurisdiction over a non-resident, right, a defendant that doesn't live there, they have to establish minimum contacts. You have those two steps from international shoe. So in addition to demonstrating the contacts are systematic and continuous, and that it would be fair to make them come here and defend themselves, you now have to show that defendant purposely availed themselves to the state of Kentucky. I'll say that one more time. I don't want you guys to be confused. So again, I'm trying to determine whether or not I can force Amazon to be under the jurisdiction of Kentucky, and I'm trying to figure out whether or not personal jurisdiction is present. So what I know as of week 2 of classes is I have to determine if Amazon has minimum contacts with the state of Kentucky. I'm going to consider those two items from international shoe, that two-part test. Does Amazon have minimum contacts in Kentucky? And would it be fair to require Amazon to come here and defend themselves? And then now I know there's another component is I have to show the court that Amazon purposely availed themselves to the benefits and whatever else the state of Kentucky. Okay. All right. So the problem with the Hansen case is that although I like the fact that it gave us one more little nugget in our quest to determine personal jurisdiction, it left a lot of unanswered questions concerning how the quality and nature of the defendant's activity is supposed to be measured and to determine whether minimum contacts are present. And so, that's fine, purposely availed itself, but what does that mean exactly? One billboard, any solicitation of business, and so as we keep going through cases, each one is going to give us another rule in our framework. So they'll answer what Hansen didn't answer essentially. So if we think back to the McGee case, and I'll give you a chance to just look at your notes from McGee briefly, remind you. And again, that's the one with the International Life Insurance Company. So if we think back to the McGee case, how can you differentiate attorney? I have it so wrong. How do you differentiate between the holding in the McGee case in Hansen? Meaning, why is there jurisdiction in McGee but no jurisdiction in Hansen?
Well, with McGee, it was made in California, and it's based in California, they also sent the ones like insurance from California, and it's back there. The difference with Hansen is that even though you purchased it in Pennsylvania from a Delaware bank and then moved to Florida and died in Florida, there's no continuous transaction for both the states.
And what about the purposeful availment Where does that come into play? The purposeful availment in the McGee case? Did the defendant purposely avail themselves to the state of California? See, I keep saying be confident. You got this. Say it out loud. Yeah, absolutely. How so? You just said it.
I would be much like based on doing business with Franklin, like throughout his like.
Yeah, so they knew they had a policy and they were actively conducting business, right? Okay, perfect. All right, so McGee, the Texas insurer mailed an offer, solicitation, to insure the plaintiff in California, thus soliciting his business in that state. So, there's a very strong argument in McGee, that the plaintiff purposely availed itself to the benefits of the state of California by, obtaining revenue from one of California's residents. In terms of the Hansen case, there wasn't any type of solicitation. At the time of the trust, again, the seller was living in Pennsylvania. So, yeah, you can say that the trust company in Hansen purposely availed themselves in Pennsylvania because they entered that initial contract with the resident in Pennsylvania, not a resident in Florida, okay? So purposeful availment, again, looks back to see whether the defendant had fair notice, essentially, of a possible litigation in the foreign state because the defendant received benefits from engaging in some type of activity. Now think about it, that's really fair. I love purposeful availment. If you're doing business or soliciting business in a state, it's fair to have you come and defend yourself if something pops up, meaning you should expect that there might be a legal issue anytime you're conducting business in whatever state it is. And so I think that's fair as opposed to, I go into a contract with someone in Kentucky, they move to Colorado, now they're trying to bring a suit, they want me to come to Colorado, I don't have any contacts in Colorado, I don't do any business there, I didn't purposely avail myself to the state of Colorado, I don't have to go there to defend myself. So we like purposeful availment. It's very wonderful. So is the court's distinction persuasive? Meaning, if Mrs. Donner had been alive, let's say we change the facts a little bit, and wanted to sue the trustees in Florida for a dispute regarding the trust, do you think, Attorney Richter, that the court would have upheld jurisdiction? So again, if Mrs. Donner had been alive, wanted to sue the trustees in Florida regarding the trust, do you think it might have been upheld?
I don't think so. I think it's the same problem because they didn't solicit the business from that state, and so I think if you have the same issue that they didn't intentionally do business with the state of Florida.
Okay, could you make an argument for the latter?
If she's still alive, and I guess it would depend on if she was actively, like in the other case, sending payments and communicating with them, then they may be able to make a case. But if it was just she took it with her and that was kind of the end of it, and hadn't established any contact from there, then it's probably
Perfect. You're both sides. You're ready to be plaintiff and defense attorney. Yes.
So that was my question. Was it pretty quick? Like when she moved to Florida, did she die quickly and then just didn't have any time for the Delaware company didn't have any time to like send her mail or?
Don't know. The facts don't tell us that, but that would be an argument you would make, which is what Ms. Richter was alluding to. Let's say that she was there and there was some interaction while she was in Florida with the trust company. You could try to make that argument then that, yeah, they knew that they had someone doing business here. They didn't cut off the policy. They're still interacting with her. Yes.
So do they have to benefit from that interaction? Like they just sent her money. That's not counted as like purposeful availment. So does that mean if this happened while she was still living in Pennsylvania, if while in Pennsylvania they never benefited from like her signing a contract and mailing it from Pennsylvania, but she's all in Delaware, everything affects Delaware?
Yeah, it's really not about benefits. Did they purposely avail themselves to that state? Did they solicit business? Are they doing any business transactions whatsoever? Is there any contact that they're making continuously with the state of Delaware? So it's not quite that cut and dry. Sorry. Yes. Why do you have a hood on? That's weird.
Oh, I'm sorry.
All right. Okay, can't see his face.
So if we take Florida out of it, is this basically just the Texas insurance case, kind of, because they did the contract, even though it's a bank in Delaware?
Yeah, I mean, in Pennsylvania, if they're doing business, say they're doing business with Mrs. Donner in Pennsylvania, then Pennsylvania would have jurisdiction over that corporation. Yeah. Any others? Yes.
So is that why they're saying it's under Pennsylvania law, not Delaware law?
No, that's a whole other class called choice of law, and it's like you spend a whole semester learning, like once you know that Kentucky or Pennsylvania, let's say once you know Florida has jurisdiction, then you have to determine, fine, so in administering this trust, do we apply Florida probate law or Pennsylvania probate law?
Is it like the Bezos divorce thing where
I haven't kept up on that. I know that's Amazon, right? They're supposed to be the most expensive divorce ever, allegedly. I don't know because I haven't read the facts.
they got married in New York and then but they're in California and they're like I think it's a family law aspect. They're trying to figure out like which jurisdiction applies to like their divorce.
I need more facts to comment, yes.
Random fact, he makes like 4.5 billion an hour, million an hour, so y'all can check that out, but that's okay.
Yeah, thanks for that. Like, we want random facts that uplift us, not that
Well, he needs lawyers, so that's good. I noticed that like 4 of the justices dissented, so was their dissent that they wanted Florida to have jurisdiction because they didn't say anything about it in here?
Yeah, so the dissent was that they wanted Florida to have jurisdiction because they felt like if a resident moves, that insurance companies should anticipate that people are going to move. And they didn't think, if you're doing national policies out of state already, you should anticipate that someone might move. And they didn't feel like that was unfair. And they don't like the purposeful availment. They think minimum contact should be enough. You shouldn't have to necessarily solicit and purposely avail yourself to that state.
That kind of sounds like that losing argument from the Buick case, like you made a car with wheels, so you could expect it in Oklahoma or whatever.
Oh, the Volkswagen?
Yeah.
Yeah,
Oh, was that later? I don't know what it is.
Buick, different class.
Yeah, that was
Oh,
torts,
yeah, definitely.
Okay, he was blending. I was like, Buick? But I get your point, Volkswagen case. And that's why, basically what's happening is, then the court gets that situation where, okay, so what you see happening in personal jurisdiction, the legal framework kind of is being slowly developed. It would have been nice if Congress had just sat down and said, this is how we're going to determine personal jurisdiction. But they were basically making the law as the different situations came up, which is sucks for us because it's like, just give me the end. I would love to just give you the end and say, here it is, but this is part of the learning process, but it would be nice, wouldn't it? I'm telling you, half of these law classes, I could be like, here you go. Go practice. Oh, yeah. Practice what I preach, right? Sorry, that's not a good thing. Well, the good thing is, if you talk to any 3Ls getting ready to graduate, they will all say that it flies by really fast, and, they may not have a job, they're ready to get out of here. But they'll say that it flies by really fast. It doesn't feel fast until your second year. It's like your second year, second semester, that's when you're like, well, I'm done. Because you know your last year, you're going to be smart, you're going to take cool seminar classes that don't have exams, that have papers due, unless son of bar, you just have to take tax. So, it'll be just a lot different, I'm telling you. You just got to get past this semester, and then it's actually fun. It's not stressful. But you have to get past this semester, and then you're good. You're like, you'll see your whole lifestyle. You're going to be normal again.
It's a new normal.
Yeah, you'll be normal. Like, you won't be reading all night and all that nonsense. Like, you'll be regular people again. So, just a year of being abnormal. All right, so which state has the strongest interest in the disputes between McGee and Hansen? So, in McGee, there was jurisdiction, and in Hansen, we know there's no jurisdiction. So, which state has a stronger interest in the disputes? I say Florida, right? You can make the argument that Florida has an interest in probating wills for their residents. You can also make the argument that California has an interest in making sure that its citizens are protected from companies who sell insurance in their state and then fail to pay out on those insurance policies. So, that is pretty much the McGee and Hansen case. We are doing really, really well. Happy for us. So, we can now do the Schaefer. Oh, shit, I don't understand. Okay, but all right. So just so you know, when I was walking away from the case, yes.
I think a lot of these causes arise from the fact that all these corporations are being incorporated in Delaware. I noticed this with International Shoe as well. Why are they all like centered there?
Are you kidding me? Delaware is like the place to be if you're a corporation. So, yeah, so Delaware, the state of Delaware, basically a lot of the way they make their revenue is making it very appealing for companies to incorporate there. They have very relaxed laws, the lowest rates in terms of the filing rates that you have to pay to file for incorporation. So Delaware has really lax laws, and that's why all the corporations, not all, but a lot of them are incorporated in Delaware. Like if you're able to get jurisdiction in Delaware, the courts, the judges are very amenable to companies because that's how the state makes their money. Delaware's like the place. You should Google it. Like you want to incorporate Delaware.
But you would think by now they would have noticed that the fact that so many of these businesses are just incorporating there for the purpose of lower taxes and then having their principal places somewhere else like International Shoe in St. Louis, Missouri, you would think they've noticed by now that that's creating numerous jurisdictional issues.
They are, but as we continue to go through the case